पर जिस हिसाब से इसके ये तो 7 साल से नीचे ही है ना फिर तो, ये तो फैन 7 साल से नीचे ही चक्कों वाला जो
Hello. Hello. Hi Pushpanjali, I think we are good to go. It's 12:05 and people will keep joining in.
Yes, sir. I welcome you all to the webinar. I would like Pushpanjali to give a brief about this session.
Am I audible to you, Khushbu?
Yes, you are perfectly audible.
Okay, thank you. Good afternoon to all my respected seniors and my professional colleagues. I'd like to welcome all of you to this most informative and captivating session for today's webinar, which is on settlement under IBC and dealing with debt below 1 crore. Before starting this session, I would like to give a brief introduction of today's topic. Due to increase in threshold limit from rupees 1 lakh to 1 crore under IBC, many MSMEs who were not able to file application under IBC can lodge an application to MSME Facilitation Council for their outstanding debt. Before heading forward, I'd like to introduce Mr. Rohit Sharma, sir, the key speaker of our today's webinar. CS Rohit Sharma, sir, is a commerce graduate, a member of Institute of Company Secretaries of India, and holds diploma in management accountant from the CIMA, UK. He joined Mamta Binani and Associates as a practicing company secretary and currently associates with the firm as a partner. He has also written various articles on company law matter and insolvency and bankruptcy code 2016, which got published on numerous websites and journals of professional institutes. Over to you, sir.
Thank you, Pushpanjali. Thank you. A very good afternoon to everyone. It is always a pleasure, when we shift our base from one place to another place. Like I have shifted my base from Calcutta to Mumbai. It is always a pleasure to meet, your office colleagues through this via this electronic mode. And therefore, I thank you very much for starting with this, coming up with this. We thought of coming up with this program because this definitely helps us to interact. And it's so happy. I'm so happy to see Mamta ma'am also today. Apparently, days pass by and we don't even get time to speak to each other. But yeah, this is a very good medium so that we can connect with each other. Anyway, now coming back to the topic, and most importantly, coming to the topic, I would say that the topic is divided into two parts today, friends. Now, the first part that is divided into is pertains to the settlement under IBC, and the second part is towards the outstanding debt for below 1 crore. Now, friends, the difficulty that we face in today's time and why we thought of coming out with this topic is because the threshold limit, like my colleague Pushpanjali already mentioned, has been increased for filing an application under IBC to 1 crore. Now, in order to file an application under IBC for initiation of CIRP against a company, the minimum default amount has to be for rupees 1 crore. Now, we were facing this difficulty with our clients also because, there are many of our clients who were having an outstanding of below 1 crore. Now, the difficulty that they used to face was that, what do we do, sir? They used to come to us saying that, we don't have any other option. So we used to always tell them that it's not that we don't have any other option. I mean, before IBC came into picture, that is, December 2016, prior to the inception of IBC, there was other laws as well. For example, recovery suit or money suit, which was already in existence before IBC came into picture. But as we all know, these laws, these proceedings actually are not a time-bound process, and turns out to be a very, very lengthy process, for which they face these difficulties as to how do they proceed in these matters. Correct. So, and this is a problem we were able to kind of happen to handle those problems at that point in time, but such sort of problems were in existence till date as well, and are in existence also, because we do come across many of our clients who wants to file an IBC proceeding, but owing to this default threshold limit, they are not able to file the application. So now the point comes as to what do they do then. That was the first problem that we actually came across, and we thought to have a session on this so that we can actually try to enlighten the our client base, or maybe our friend circle, as to how do they advise their clients in turn who can proceed further. So that is the reason to come up with this topic in the first instance. And the second topic that becomes very crucial at this point in time is settlement under IBC. Now, friends, under IBC, settlement has already been envisaged in the sense as to how is a company supposed to proceed with settlement, or how the corporate debtor is supposed to proceed under settlement is very well envisaged under the code. But still, having that said in the code itself or the regulation itself, people were there who used to face this problem as to how do they settle the matter. And especially the main important question that comes around the mind is, when do they settle the matter? Because, an application when filed under section 7, 9 or 10, 7 being the application for financial creditors, 9 being the application filed by the operational creditors, and section 10 application being filed by the corporate debtor, as we all are aware of these provisions of the code. So when these applications are filed, and this varies from bench to bench, because the law prescribes a time that when an application is filed, within a period of 14 days, the NCLT is supposed to adjudicate the proceedings and initiate or reject the application. Initiate in the sense, initiate the CIRP or reject the application. But since the inception of the code, we have seen that this has not been happening owing to the quantum of applications or quantum of proceedings being filed before the NCLT. So now the time period varies from one NCLT to another NCLT, in the sense that how much time a particular NCLT might take, around 6 months to 1 year to adjudicate an application. On the other hand, the another NCLT is taking around 2 to 3 years. Now, the difficulty is absolutely varying from one NCLT to another NCLT, because there could be a matter which is filed before, say, Guwahati bench or before the Cuttack bench, where the number of matters listed on a regular basis varies from, say, 20 to 30 matters. Now, on the other hand, if you take Calcutta bench, for example, or the Mumbai bench, for example, or the Delhi bench, for example, despite the fact, and friends, I reiterate, despite the fact that Mumbai bench and Delhi bench has around 5 benches in their hands, still the number of matters being listed on a regular basis before all these 5 benches is tantamounting to approximately 125 to 200 matters. Still, and therefore the bench is not in a position to kind of adjudicate the application within a time frame given. And now this dilemma, because an application is filed against a company, now this dilemma actually stays as to who they go against and when do they try and settle the matter. Because they have an option to settle the matter before the application is admitted. They have an option to settle the matter after the application is admitted. They have an option to settle the matter at a very later point in time after the application is admitted, right? So therefore, this difficulty was, pondered upon by so many of our clients. So we thought that we will come out with this topic as well as to how to go about it. Anyway, now having said that, the reason for coming out with both these topics, so let us start with the session, and let us start with the first topic, and that is settlement under IBC. Now, friends, the reason for me to not have prepared a PPT, and there's a very, very valid reason as per me, if I say so, because, when the session is actually ongoing, and now that the tenure of the session that we are keeping at this point in time is very less, just to have an interactive session amongst all our clients or all our colleagues, so that we can get to know each other and we can actually try and enlighten, or we can get opinions from you, from your good selves as well as to how to go about future matters. Now, while sharing the PPT for an 1 hour session, the time is actually wasted in sharing the PPT or maybe transpiring from one page to another page. And that is the reason I thought it is better that I speak now that the topics are not very new, because IBC is already 6 years old. I believe people are aware of this topic. And therefore, I thought that if had there been any amendment, we could have gone ahead with a PPT as well. Anyway, having said that, now friends, settlement under IBC. The first reason is why to settle. I mean, even if the IBC is initiated against me, why is there a need for me to settle? Correct. The first reason that comes into our mind is the repercussions are very harsh under IBC. Unlike any other law for the time being in existence, the repercussions under IBC is so harsh because the company is actually taken away from the directors. Now, friends, we all know that a company to a director is like a baby to a mother. Correct? Because you nurture the baby, you help them grow, you help them be strong, and then suddenly, in a whisk of a second or in a whisk of a moment, the company is being taken away from the directors. Now, no director or no mother would want their baby or the company to be taken away from them. Correct? So there comes a point where the director or the promoter would try, every luck roaming around from pillar to post to try and settle the matter, so that they can get the reins of the company back into their own hands. And therefore, we feel that since the repercussion is so harsh under IBC, the promoters slash directors come forward to settle the matter. So if the debt payable and it is due, we suggest the client, if it is payable and it is due and it is to be paid, because there are numerous applications since the IBC came into picture, there were many fraudulent applications also filed, under the garb of IBC, which is a recovery mechanism. There were many applications filed to kind of extract the money from the company by pressurizing them of initiating CIRP against them and taking away the company from their hands. Right now, if you blackmail someone by way of this application, these things are ought to happen, right? So therefore, if it is due and payable, we suggest the client that you settle the matter, where the company, where the financial creditors in a company is huge in number. The banks are there in existence. The banks would actually want to restructure the debt themselves. And therefore, we do not come into picture anywhere. Now, on the other hand, friends, if suppose in a company, there are numerous operational creditors, correct? And there are very few financial creditors. So we happen to come across such clients as well. And today, friends, I would actually be talking with my practical experience, as limited knowledge as I have of this IBC and the limited experience that I have. I would like to actually kind of share stories, practical stories, as we have actually come across, because we happen to come across a client where the financial creditor was very less. The company was in a position to pay off the debt of the banks or the a loan of the banks, timely repayment of the interest, but it was not in a position to pay out its operational creditors. So this client approached us, apprehending that an application or a demand notice would be filed against the company. So where do they go? Where do such sort of companies go? Because they have been in a position to kind of pay out the debt to the bank, and they want to pay to the operational creditors also. But the difficulty that they are facing is that they want some time, because the company, because like we have seen in COVID, the jute industry in West Bengal had dropped down drastically. Many of the jute industries got closed. Many of the companies got closed because of non-availability of jute in the market, or the jute being available in the market at a very higher price. And therefore, friends, what we have seen is such industry was facing a lot of difficulty to pay out its operational creditors. Whereas in terms of payment to the financial creditors, the company was able to get the money from their own funds and pay to the banks. Correct. Whereas this was not in a position in case of an operational creditors. Now they see that as the COVID is actually passing by, they are in a position to revive the company. The jutes are being made available to the company, and in a lapse of say maybe 2 years, 3 years down the line, the company will be back in its full force and will be able to resume business in the normal position as it was pre-COVID. Correct. So now what do this sort of a company do? Because if an application is filed against them, they will not be in a position to pay off the debts to the operational creditors. Now, and unnecessarily the CIRP will get initiated. So therefore, what we suggested our clients is that to go ahead and restructure your debts. Restructure your debts in the sense, now we have got two more options in this. If you are an MSME, there is an option of pre-pack. That is one option which is already there. Now, the second option, if you are not an MSME, we can still think of restructuring your debt in a manner where no application can be filed, or we can enter into a negotiating talks with the creditors, enlightening them also that they will definitely, they might not be able to retain that amount, once they initiate CRP against them. Because for obvious reasons, they are an operational creditors, they're not the financial creditors. So they will not be able to get as much amount as we might be able to pay them in a lapse of say 1 year, 2 year, 3 year down the line, if we are able to revive the company. Correct. So debt restructuring is also an option. Now, suppose we don't want to restructure our debts. Then comes the point people actually have to go ahead and settle the matter. Correct. And when and how do we settle the matter? There are 3 options. I repeat, when and how do we settle the matter? There are 3 options that is available to us. The first option is when an application is filed against us. Now, when an application is filed against us, a copy is served upon us. Now, in this matter, while I'm saying this, I am the company respondent / corporate debtor. Correct? So an application is filed against me. I can immediately go ahead, try and negotiate and settle the matter. The second, while the application is being adjudicated by the NCLT, I can settle the matter. Now, the second option is CIRP is initiated against me. Correct? The CIRP is initiated against me and the COC constitution has not taken place. Now, what is a COC? We all are aware. I am not dealing with the basic information of IBC for the time being, considering we have a very limited time frame. So therefore, once before the COC is formed, we can settle the matter. Now, the second option is the COC is constituted, but the EOI is not published. Correct? Now, what is an EOI? Expression of interest, inviting bidders to put in their resolution plans to purchase the company or revive the corporate debtor. Correct? So the first stage is before the constitution of the COC. The second stage is COC to EOI. Now the third stage is after COC and after EOI. I repeat, the first stage is before constitution of COC. Second is after constitution of COC and before inviting EOI. Third is after constitution of COC and after inviting EOI also. Correct? Now the law lays down, and friend, this is really important. The code, the regulation lays down different modus operandi for all these 3 methodologies when you enter into a settlement. And I have seen, our firm have seen on numerous occasions, the applications for settlement are generally not dismissed on the ground of, the rules not being followed or the application is not in a proper format. We have hardly been able to see that. But what we have seen is the bench on numerous occasions directs the application when the application is not in a proper format to amend the application. Now, when I say amend the application, we might feel, we will amend the application. How? This is not a big deal. I mean, when the matter is settled, what is the big deal? Now, I will explain you the big deal, friends. What generally happens is when a CIRP is initiated, IRP already has the reins of the company in their hands. Correct? Now, as the days pass by, the grip of the IRP on the company is getting stronger and stronger. And the grip from your hand of the company is being reduced. You're not being able to have that grip. In the sense, as the days pass by, the compliance part, the IRP is also court officer. RP is also court officer. He's bound by law. He's supposed to follow the law and move ahead with the CIRP. And as we all know, IBC is a time-bound process. The IRP, RP is supposed to move forward with the application, with the process of the CIRP. So they are moving forward. Now, the difficulty lies, friends, when the court actually directs us to amend the application. Around 3 to 4 days gets wasted to amend the application. Around 5 to 7 days gets wasted in getting the amended application listed. And around 5 to 7 days gets wasted in getting the order of revival or getting the order of withdrawal of CIRP from the NCLT. So all in all, we are actually losing around 15 to 20 days only, owing to a very, very maybe either minuscule problem, maybe difficulty with the application or drafting of the application, or maybe some major difficulty with the application. But any which event, the promoter director of the corporate debtor is on the losing end, and they are not being able to proceed with the taking back the reins of the corporate debtor into their hands. And therefore, it is very, very important, and it is really important for us to follow the code or the regulation as envisaged and the provision has to be followed, because there are certain bench which is actually a stickler for rules, and we cannot kind of think that we will file an application. Because see friends, I'll tell you, when I mentioned that a settlement actually takes place, and I'll tell you very minor differences also which is there, now where in section and the code is the settlement described. Section 12A of the code describes the settlement. Regulation 30A of CIRP regulation describes the settlement regulations. Correct? Now section 12A read with regulation 30A is supposed to be a section or regulation for withdrawal. Correct? So now section 12A generally only tells us the settlement after initiation of CIRP under section 7, 9 or 10. However, the regulation tells us the modus operandi to be followed while filing the application. Now, if I tell you the basic differences, when an application for settlement is filed before constitution of COC, फॉर्म FA बोल के एक चीज होता है जब हम सेटल करते हैं तब, which is an application, which is a form basically or a letter which is actually submitted by the operational creditor or financial creditor at whose instance the petition was initially admitted. At whose instance the petition was initially admitted, that particular petitioner actually gives the form FA to the IRP/RP for saying that you kindly get the application withdrawn because I have already settled with the corporate debtor. Now that is prescribed in the regulation 30A. Now what happens after constitution of COC and before the invitation for EOI? After constitution of COC, friends, this application is supposed to be filed by the COC. Before constitution of COC, this application has to be filed by the applicant through the IRP. I repeat, once the CIRP is initiated before the constitution of the COC, the application is supposed to be filed by the IRP by the applicant through the IRP. Correct? Now in the second instance, like we mentioned, COC से EOI के बीच का जो phase है, COC चालू हो गया, EOI के पहले का जो phase है, in that particular situation, the application is supposed to be filed by the COC. And in the third instance, that is after COC and after EOI, the application is supposed to be filed by COC only, but with an addition. Now, what is that addition? The COC actually has to tell the court, the committee of creditors actually has to tell the NCLT as to why did they feel it necessary to settle the matter after the EOI was published. And the reason for the same is because, friends, jab EOI issue ho gaya, when the EOI is issued, it is like an invitation given to the other persons, inviting their bids to buy to purchase the company. Correct? Now that cannot be a situation if I have already invited people to kind of come and purchase the company, and on the other hand I settle the matter with the corporate debtor or with the erstwhile directors of the corporate debtor. Correct? The reason being, जब मैंने एक पर्टिकुलर चीज का प्राइस एक्चुअली मार्केट से बुलवा लिया है, मेरे को मे भी 10 रुपया मिल सकता है, मेरे को मे भी 20 रुपया मिल सकता है, तो मैं क्यों अभी बिना वो प्राइस जाने सेटल कर ले रहा हूँ डायरेक्टर्स के साथ में. एंड देयरफॉर द लॉ मैंडेट्स द कमिटी ऑफ क्रेडिटर्स टू स्पेसिफाई दिस थिंग as to why are they wanting to settle the matter after invitation of EOI with the erstwhile promoter directors of the corporate debtor. This is apropos to the settlement under the IBC. Correct? Now, friends, 2 to 3 things which is really important, and to start with the very important judgment that has been recently brought out by the Honorable Supreme Court, delivered by the Supreme Court in the matter of Siva Industries. And maybe I'll give the link also. I've written an article on this, which got published in India Corporate also, and it is a good article. I mean, not that I'm boasting about the article, but it is a good article. You can go and check that article out. But friends, this is a fourth leg. Let me repeat. This is the fourth leg of settlement, which has been brought out by the Supreme Court through this judgment. To very briefly inform you guys as to what this judgment is about and what is this fourth leg of settlement. Friends, till now, what I have told you is that the settlement can actually take place before the COC, COC to EOI, and COC EOI ke baad mein. Now, when a corporate debtor, there is no buyer, there is no resolution applicant, the company is forced into liquidation. And once the company is forced into liquidation, there is hardly scope of any settlement with the erstwhile promoter directors. There is a scope of section 230, 232 of the Companies Act, which is for a very limited time, that is 90 days after the initiation of liquidation, that the liquidator can actually try to find some, if there is any compromise arrangement happening with respect to 230, 232 of the corporate debtor. Apart from that, there is no settlement as such. There is hardly any scope of settlement. But what happened through this judgment? In this matter, friends, the CIR, there was no resolution applicant. The corporate debtor was pushed into liquidation in the absence of a resolution plan as mandated by the law. After the liquidation application was filed, the directors, promoters of the corporator came into picture, saying that, look, giving an application to the NCLT saying that, look, we want to give a proposal to the COC members. Now that the company is being pushed into liquidation, we want to give a proposal to the COC members to settle the matter at this stage. Now, I know for a fact that the CIRP period is long over and the COC is no more into place. But I request you, that is the applicant, the director actually says to the NCLT that I request you to allow to reconstitute the COC to consider my plan, to reconsider my proposal. NCLT directs the reconstitution of COC after the CIRP period got over. Correct. Now, after the CIRP period got over and the reconstitution of COC was allowed, this plan was put forth. And to our amazement, friends, the plan actually got approved with 100%, with 96% majority of the COC members. And when the application for liquidation was filed, what happened subsequently? After the plan got approved as per mandate of the law, the RP filed an application under section 12A before the NCLT saying that, the settlement has already taken place after constitution of COC and after EOI publication. And this is the application, you kindly allow for withdrawal of CIRP. What does the NCLT do? NCLT rejects this 12A, saying that, come on, man, you have already filed the liquidation application. How can I allow your 12A application? Correct. Now the liquidation application was floated and liquidation was ordered against the corporate debtor. The corporate debtor was pushed into liquidation and that 12A application got rejected. Being aggrieved by this order of the NCLT, the promoter directors went ahead before the NCLAT. The NCLAT allowed the 12A application. The NCLAT also disallowed the 12A application, saying that there is no provision in the law for settlement after for a proposal or the settlement. And they actually said this thing, that this is not a repayment plan, but this is only a proposal, a business proposal. And without receipt of a single penny by the committee of creditors, how are they going ahead to settle the matter? Being aggrieved by the order of the NCLAT, they moved before the Supreme Court. Now, what does the Supreme Court do? The Supreme Court says that the commercial wisdom of the COC is paramount and there cannot be any hindrances or there cannot be any adjudication against or towards the commercial wisdom of the COC. If the COC is actually feeling that, it is good, it is okay, the plan is okay, even if I do not receive a single penny at this point in time, and they are actually approving the resolution plan, the proposal put forth by the promoter directors, the proposal is accepted, 12A is allowed. So friends, this adds the fourth leg for settlement, which is settlement after liquidation was ordered. This may not happen in each and every scenario, but this is also an option. This can also be an option that the promoter directors can think of to try and settle the matter, because, friends, on majority occasions, now coming up with experience number 2, practical experience number 2, we have also seen situations where the application is actually filed by some party against the corporate debtor. The corporate debtor wants to settle the matter with the applicant. They go ahead, tell them that, come on, man, kindly try and settle the matter. What does the applicant do? They think that, they are in the powerful position now. They have filed the application. They don't want to negotiate. They want to get some extra cut after filing this application. Say they have filed an application for 10 rupees. They want to kind of obtain 12 rupees now, maybe say 14 rupees now. Now the applicant is already, once the application is filed against the corporate debtor, which means the corporate debtor is not in a position to pay. Generally, this is meant that the corporate debtor is not in a position to pay. If they are not being able to pay your legitimate dues, how are you expecting to reap or to extract extra money from the corporate debtor? Therefore, we have seen such situations also where the application is filed, the settlement talks take place today, and then the settlement takes place after the talks of settlement takes place after the application is admitted, so on and so forth. So now, after explaining these 4 legs of settlement, I believe we will be in a good position to kind of understand as to when and how much to settle for, and if at all to settle during or after the initiation of CIRP. I believe the first part of the session is done here. And if we have any questions, we can definitely take that, or I can move on to the second limb of the session. Pushpanjali, do let me know if we have any questions, or I'll move forward.
Sure, sir. Sure, sir. I will let you know. Sir.
I think we will move forward, and if in the meantime we'll have any questions, we'll address them. Huh?
Yes, sir, sure.
Okay, now coming to the second limb of the session, which is how to deal with the debts which is pertaining to below 1 crore. Friends, we have 2 options here. Like we had earlier, when the application for CIRP, when the IBC actually came into picture, we initially had a money suit, which we all know is a very, very lengthy process, which runs for approximately 10 years, 15 years, in odd cases goes for around 25 years also. So it does not make any sense for to move ahead with the money suit right now. When IBC came into picture, many of the applicants started to file application under IBC because initially the threshold limit was 1 lakh rupees only. Now, after the threshold limit was increased from 1 lakh to 1 crore, what should the other creditors, what should the other people do? Because, now that they do not have any other option. So what we happen to see after COVID, friends, that the MSME forum actually became really strengthened with the new amendments, with new circulars, and with the new powers that the government actually gave to MSME forum. That is the Micro Small Enterprises Facilitation Council, with respect to filing of cases or with respect to adjudicating the applications filed before them. So we came across that MSME could be a good forum for such, for such creditors, because now they do not have any other option. Their outstanding is below 1 crore. Where do they go? So we started filing the application against MSME. Now there came one more problem. Actually, not one more problem, but 2 more problems. The first problem being the MSCFC. The provisions of MSCFC is only for the micro and small enterprises. For what should the medium enterprises do in such a situation? The medium enterprises do not have any other option. So that was the first problem that we encountered. Now the second problem was MSCFC is only available to other entities except traders. Now, say if I'm into a trading activity, that is, I take goods from one person, I sell goods to third person, I earn only a minuscule of, say, maybe brokerage or things of that sort. If I am into a trading activity, I cannot obtain the benefit of MSCFC. And the second one, like I mentioned, was if I'm a medium enterprise, I cannot move ahead with MSCFC. So we will actually tackle these 2 problems at a later point in time, but let me actually tell you or give you a brief data of the power of MSCFC since COVID, friends, because this is important for us to know the data also, as to why should we go for MSCFC altogether. Now, to briefly give you data, which is actually available on the Samadhan portal also. And this is the data as on June 2020. Now, the total application filed under MSCFC was 1,16,312, which involved an amount worth 6873.60 crores. I repeat, 1,16,000 odd cases having around 6,873 crores. However, against these number of applications being filed, total 17,632 cases were disposed of by the MSCFC, which involved an amount to 4,520 crores. Now I'll repeat and very slowly. 1,16,000 cases filed. Against 1,16,000 cases, 17,000 odd cases were disposed of by the MSCFC. Now, 1,16,000 applications being filed was for total amount of 6,800 crores. Against 6,800 crores, MSCFC was able to dispose of cases having amount of 4,500 crores. Now, application which got mutually settled only, which means, after filing the notice or after sending the notice, which is total to 11,255 applications got mutually settled. Application which are being heard is 30,000 approximately, and application which got rejected is 26,000, 27,000 approximately. Correct. So this is the data, friends. Now, if a facilitation council is being opted for by companies or by applicants having total outstanding of approximately 6,000, 7,000 crores, we can actually try and understand the strength of MSCFC at this point in time in our country. Correct. So giving you this background, let me also tell you the brief benefits and the the disadvantages are obviously there as well. So let me also tell you about the advantages and disadvantages under MSCFC. Now, the first advantage that we see basically for filing a case is there's no limitation, friends. There's no limitation. Now, in order to file a case under maybe say money suit or any other proceedings in our country, there is a difficulty that lingers around is the limitation. What is the limitation period? We all are aware that generally for money suit, it is 3 years. If there's a limitation act, all in all different.
Sir, I think we cannot hear your voice, sir.
Acha, sorry, it got muted, I believe. I hope I'm audible now. So now, so basically, what we see the number of applications being filed under MSME is largely high, and the procedure that we were talking of was limitation period being not enabled under MSCFC. So now, friends, what happens is now if I have an outstanding of 10 years old, 5 years old, I can actually proceed and file a case under MSCFC. Now, what is the procedure for MSCFC? That I have to send a notice. I have to send a notice like under section 9 of IBC. I am not trying to juxtapose IBC with MSME at this point in time, but I'm only trying to envisage as to what can be the provisions, similarities between IBC and MSME. The repercussions for obvious reasons are not that harsh under MSME in comparison to IBC, but just to start with and juxtaposing IBC with MSME. So the first thing is we have to send a notice. After, even though there is no limitation, we have seen on numerous occasions that the companies do come for settlement only after receiving the notice. So irrespective of the period of the debt, in the sense, even if your debt is say 10 years old, 15 years old, we have seen companies coming forward to settle the matter. So that is the first advantage that we get. The second advantage that we see is the expeditiousness in these proceedings. MSME, friends, is an expeditious process. It is not something wherein you have to keep on arguing the case, the matter gets deferred, nothing of that sort. The case actually gets listed in a very, very short while wherein you can actually argue the matter and get the matter disposed of also ASAP. Not that you have to keep on arguing the matter, the opposite party actually keeps on getting paid, nothing of that sort. So this is the second benefit that we have seen. Third benefit that we have seen is it is cost effective also. Since there is not a lengthy arguments being taken place, since there is no intervention of a lot of judicial proceedings, therefore this process can be actually called something which is cost effectiveness also. So these three benefits are something that we have been able to come across. For obvious reasons, there are other benefits also, but I don't want to eat into the time. We are already 15 minutes left with the session, so I'll just try and move fast. So those are the benefits that we have actually seen under MSME. Now coming to the disadvantage that we have seen is the repercussions under MSME is not as harsh as IBC, but some or the other place, friends, we will actually have to settle down, because that's what the fate has for us, because there is no other proceedings. Either we go and file a summary suit, which I'll discuss in some point in some time, and the other option is to file a case under MSCFC. Third option that is there, that obviously is there, is to file a money suit, but that like I mentioned, it takes some good time to be adjudicated upon. Correct. So this advantage is that repercussion is not that harsh. We get a decree if the other side fails to pay while the proceedings are ongoing, and that decree has to be executed after the decree is obtained. Now, in order for execution of decree, we will actually have to file case depending upon the quantum of the debt before the city civil court or before the high court, and the city civil court or the high court direct the local police officer or the jurisdictional police officer to file the case or to get the assets of the respondents in their own possession, sell the assets, reap the money, extract the money from selling of those assets, and to pay to us. That is one option that is there. That is how the decrees are basically executed. So that is one of the major, and that is the only disadvantage that we see under MSCFC. Apart from that, I don't think there is any. I'm open to opinions as well if we happen to see anything else. Now, what is the procedure, friends? Very briefly, I'll say the procedure also. We send a notice, and it is like an online notice only. We fill in the form, we attach the documents as required. That notice is being sent to the other side, and an intimation is being sent to us also. The law provides for us to wait for a period of 15 days, either to get the matter settled, or the notice gets converted into a case. We don't have to kind of draft a new case. The format is prescribed for notice also. The format is prescribed for the case also. We have to draft the case, as in put in the case data in the application format, get the hard copies of the case filed before the local or the jurisdictional MSCFC, and the case starts getting listed and the hearing starts being taken place. Now, friends, after the hearings takes place, and if a favorable order comes in favor of the applicant, we get a decree like I mentioned earlier. Now, if the application is not getting admitted, in the sense if the application was or the case was filed not for a genuine cause, the application gets rejected for obvious reasons. Correct. So there is also the MSCFC also has a power. If the MSCFC happens to see that there is a dispute between the parties, a genuine dispute, the MSCFC can refer this matter to arbitration also. I repeat, if there is a genuine dispute, which if I'm the applicant, has not chosen to share it with the MSCFC, and the other side represents the same, and the MSCFC is convinced that there is a dispute, a genuine dispute, it can refer the matter to arbitration. Now, the arbitrator basically passes an award, which is brought before the MSCFC. Accordingly, decree is passed or the rejection happens. Decree if an order of favorable order is passed in favor of the applicant, and rejection if an order is passed in favor of the respondents. That is actually what happens. Now, this is basically the procedure. And coming to the third part, that is the sub part of what to do about debts below 1 crore. The second part is Order 37 of CPC. Now, what is CPC? Civil Procedure Code, which is a summary suit. And friends, it is similar to, now the CPC is basically similar to MACFC in a sense. How does the summary suit basically works? And how is it different from the normal procedures? Friends, a summary suit is a legal procedure which is actually supposed to be very, very faster, in the sense similar to MACFC. But how is it faster? Because this sort of proceedings are only initiated by the applicants when there is a guarantee. I repeat, when there is a guarantee to pay off the debts. For example, if there is a promissory bill, promissory note, bills of exchange, if there is a PDC, post-dated checks being given to us against the amount which is outstanding, in such sort of scenario, we can go ahead and file a money suit. Now, what is the purpose of bringing the summary suit into picture? Friends, the summary suit was brought out by the government with an intention to restore the faith of the business people, or the people who are engaged into business, in the institution of court. Because, like I mentioned, money suit has been running since ages in our country or around the world. But it takes a very, very longer period of time for the money suit to get adjudicated upon. Correct. Therefore, what do the creditors do? And therefore, they came out with this summary suit. We find
Sir, again, sir, there's just some voice problem from your end.
I think the moderator is actually muting everyone. So I believe that is the problem. Am I audible now?
Yes, sir. Yes, sir. You are audible. You are audible.
Mute हो रहा हूँ मैं मतलब ज़्यादा. Anyway, now coming back to the topic. What are the conditions? Like I mentioned, the guarantee has to be there towards the outstanding loan. There has to be a written consent, friends, which is really important. Written consent in the sense there has to be an agreement. Written consent in the sense there has to be a written agreement. It cannot be like Contracts Act, wherein the oral agreement between the parties can also actually turn out to be an agreement in written, or a formal agreement. In this situation, there has to be a written agreement. There has to be a guarantee, and most importantly, there has to be a fixed sum of money. We cannot file a case under a summary suit before the court saying that I have an outstanding of in the range of say 15 lakhs to 20 lakhs. Cannot be adjudicated in the summary suit. And therefore, these three conditions has to be met before thinking of filing before the summary suit. How does this summary suit takes place? The procedure is, I file an application I file a suit against the respondent. After the suit is filed, after attaching or annexing all the data that is there, all the attachments like I mentioned, apropos to kind of assail the conditions as required to file under the summary suit. After this application is filed, the matter is heard for the first time by the court. And now the court also varies in the sense depending upon the quantum of amount. Every state in our country has different quantum of amounts with respect to filing of such summary suits. Correct. So as per the jurisdiction, the cases are filed and all these three conditions are met. The first hearing takes place. When the first hearing takes place, the plaintiff actually has to establish the case before the court. After the case has been established, summons will be issued. When the summons are issued by the court, and if the respondent or the defendant does not appear before the court within a period of 10 days from the date of the first hearing, the plaintiff has an option to file a summons of judgment. I repeat, first the hearing takes place, summons are issued upon the defendant. If within a period of 10 days, the respondent does not appear, the summons of judgment can be filed by the plaintiff. I will explain what is summons of judgment. Now, first understand, what if this defendant actually appears within a period of 10 days time? If this defendant appears within a period of 10 days time, the defendant has to file its appearance before the court. Once the appearance is filed by the defendant, the said appearance is on an affidavit and has to be served upon the plaintiff also, saying that, look, I am appearing before the court, let us meet in the court only. Correct? And we will fight our case before the court. Now, the fight word could not be a right nomenclature in case of a summary suit, because there is no fight as in, proper fight, because the defendant is not given as much as an opportunity required under the ordinary suit. In summary suit, the defendant is not given so much of an opportunity. Like I mentioned, if the defendant does not appear within a period of 10 days, the plaintiff can file summons of judgment and the judgment will be delivered in favor of the plaintiff if the court is satisfied with the case. In case of an ordinary suit, and we have seen on numerous occasions also, when the defendant does not appear on the basis of a court notice, a public advertisement is directed or things of that sort are directed, and the appearance is actually awaited for the respondent also. However, in case of summary suit, appearance of the defendant is not awaited at all. The judgment can be passed, and therefore this is called a summary suit. Now, when the defendant actually appears within a period of 10 days before the court, they file an affidavit, they file an appearance service. After the affidavit of appearance is filed, the matter is heard after 10 days period. The plaintiff and the defendant, both parties appear. The defendant actually has to inform the court, that has to basically inform and satisfy the court that why this case filed by the plaintiff is not eligible to be filed under the summary suit, which is the three conditions which I mentioned earlier are not met by the plaintiff, and therefore the plaintiff is not eligible, the case is not eligible to be adjudicated under summary suit. By the verbal arguments of the defendant, if the court is convinced that this case does not, maybe there is a genuine reason, or there is a genuine dispute with respect to the outstanding, the court actually can direct the respondent to file the leave to file their affidavit of reply. Once the leave of affidavit of reply is filed, the defendant files its affidavit of reply, and if the court is convinced that there is a dispute, the money, and this is important, friends, if the court is convinced that there is a genuine dispute, the summary suit is converted into an ordinary suit. This is the repercussion of, like I mentioned, every coin has two sides. This actually proceedings also has two sides. Like I was still now mentioning one side of the suit. The second part, the other side of the suit is if the court is convinced that there is a genuine dispute, the summary suit gets converted into an ordinary suit, and then it gets adjudicated. Now there is a proceedings for inviting evidences and inviting everything. The procedure of an original suit is being carried forward, whereas in case of a summary suit there is not such a problem. Now I will tell you three major timelines, or maybe three major occasions wherein you are in a better position if you are filing a case under summary suit. Leave to defend is not given as sought for by the respondent defendant. They have to basically establish a case. They have to envisage, they have to enlighten the court or satisfy the court that they have a genuine dispute in the matter. If the genuine dispute is not established, the court actually passes a judgment/decree in favor of the plaintiff, and that judgment decree can be executed by the plaintiff. Correct? However, in case of an ordinary suit, we have seen that in the absence of the defendant, the order cannot be passed. Correct? So this is one of the major occasional benefit that the plaintiff actually can reap out of it. And in case of a very, very ingenuine case, in the sense if it is actually filed to extrapolate money from the respondent, at the very threshold, the suit is basically converted into an ordinary suit. Because like I mentioned, when the first hearing actually takes place, the plaintiff is supposed to establish a case before the court, satisfy the court, convince the court that the case is eligible to be filed again under the summary suit, and therefore the same can be adjudicated upon. Now, having said that, friends, we, like I mentioned, to summarize very briefly, because like it is already 1 and I don't want to eat in the time. So to summarize very briefly, we have got 2 options, MSME and under order 37 of CPC, that is summary suit. Under MSME, like I mentioned, the advantages, disadvantages. Under CPC also, under summary suit also, there are certain advantages, disadvantages. Apart from these 2 options, what we have over time seen is there is obviously RERA for home buyers. I'm not getting into the home buyers and the RERA at this point in time. We can have a different session on the same. But apart from these 3 limbs, I don't think if the creditor has an outstanding of say less than 1 crore, would go ahead for a money suit until unless they can actually expect something extra to extrapolate from the corporate debtor or from the respondent company, or there is something extra to be taken away from the respondent company. So having considered everything, all of these angles, we have come across that these 2-3 options are the best options for the creditors having an outstanding for less than 1 crore. We are open to opinions also. My friends who have joined the session, if they have any further opinions as to how to go about other options also, we can definitely discuss this in the coming sessions. I think I'm done here. Thank you.
Sir, I would like to take a few queries if anyone has.
Yes, please.
Sir, I think the session was so good that nobody has any queries yet.
Rohit, yes, Rohit.
Hi, Shriram sir. Hi.
How are you? Fine, you are done well. And I also wish to inform you that apart from this MSME and RERA and the summary suit, we can also file the case before the commercial courts. Commercial under the constituted under the Commercial Courts Act 2015. The threshold limit is more than 3 lakhs. So if the threshold limit is more than 3 lakhs, you can file a case before the commercial court. And firstly, the matter will be referred for the mediation. Okay, firstly, the matter will be referred for mediation. If the mediation fails, the report will be forwarded to the concerned court judge, and then the matter will be taken into consideration further. And another one is in this MSME case, whenever there is an award is passed, an appeal preferred by the respondent, if the appeal is to be prepared, he has to make a deposit of 75% of the award amount. Otherwise, this appeal will not be considered. So it is another one important point which we have to consider with respect to the MSME. And that's it. Any other points which you want to ask me?
I think apart from this, we don't have any other options for outstanding amount of say less than 1 crore. Now for commercial court also and for RERA also, the scope is actually limited to if I have a dispute with respect to my home, and then I go before the RERA forum, or for commercial suits also. For commercial suits also, if I purchase certain goods and I have a dispute with respect to the same, then I can go for commercial courts. But apart from these 3-4 options, I don't think so.
Yes, another one point you have to note down in the MSME Act is dispute means any defect or deficiency in goods supplied or services rendered. The dispute should be raised within 15 days from the date of providing of the goods or receiving of services. Within 15 days, they have not pointed out or brought notice to the supplier that there is a defect in the goods, a defect in the services, then it will be taken as a genuine dispute. Okay, so within 15 days you have brought to the notice, and the goods is defect in the goods is rectified, or service is also deficiency in services also rectified. Then the date of rectification of that service or defect in the goods is removed. That date will be taken as deemed date of acceptance of goods or services. Thereafter, they cannot deny that there is a dispute. They cannot say that there is a dispute, sorry. So they cannot come and say that no, there is a dispute. As like in IBC, before sending out demand notice, you can send a mail stating that there is a dispute. But in this case, it is not possible. Once you have accepted the goods or accepted the services, taken the services from me, and you're utilized and benefit of the goods or services, then definitely you have to make the payment.
True.
This is the purpose for the benefit of the MSMEs. This act was brought into force. So with this, I conclude my speech. Okay.
Thank you, sir. Thank you so much.
Sir, now I would like Pushpanjali to give vote of thanks.
Am I audible properly, Khushbu?
Yes, yes, yes.
Thank you. I would like to express my heartfelt gratitude to all of you for your presence and contribution to make this webinar a great success. And thank you, Rohit sir, for enlightening us regarding the topic settlement under IBC and dealing with debt less than 1 crore. And I hope we will get such kind of session from you in future also, sir.
Certainly. Thank you so much. Thank you so
Sir,
much.
we shall connect soon. Thank you so much, sir.
Thank you. Thank you.
Thank you, Rohit.
Ending the session.
Thanks for your explanation with respect to IBC and everything. Thanks a lot.
Thank you, everyone. Thank you.
Thank you. Thank you.